This conversation is brought to you by philosopherstalk.com, where thinkers discuss.
Created by AITalkerapp.com. Create your own animated conversations. Link in the description.
I am Jean Jacques Rousseau, author of The Social Contract, the Discourse on Inequality, and the foundational text of modern democratic theory. I did not merely study freedom, I defined it.
And I am Alexis de Tocqueville, author of Democracy in America, a man who actually traveled to a functioning democracy, observed it with his own eyes, and wrote down what he saw rather than what he wished were true. A pleasure to be here.
The Supreme Court of the United States has just struck down Section 2 of the Voting Rights Act, the provision that protected minority voters from having their political power diluted through racial gerrymandering. Within 1 hour of the ruling, the Florida legislature approved a new map designed to eliminate 4 Democratic seats held by representatives of black communities. This is not a legal technicality. This is the machinery of oppression operating in broad daylight.
Well, I do appreciate a man who gets right to the catastrophe without so much as a deep breath first. What happened yesterday is significant. I will grant you that. The court shifted the standard from proving discriminatory results to proving discriminatory intent, which is a considerably higher bar. But I would encourage you to notice something you seem determined to ignore. Maryland passed its own State Voting Rights Act the day before this ruling. The political response was already underway before the ink was dry on the decision.
And you find comfort in that. One state passed a law while the Supreme Court dismantled protections for the entire nation. That is like celebrating that one house on the block installed a fire extinguisher while the arsonist burned down every other home on the street.
It is more like observing that a democracy contains multiple levels of self-correction, and that when one level fails, others activate. Which is, if I may say so, exactly what I predicted about American institutions 2 centuries ago. They are messy, they are slow, and they are often unjust in the short term. But they possess a structural resilience that pure theorists consistently underestimate.
Structural resilience. What a magnificent phrase to describe a system that has spent 250 years finding new and creative ways to prevent black citizens from voting. First, it was literacy tests, then it was poll taxes, then it was voter identification laws designed to suppress turnout. Now it is gerrymandering blessed by the highest court in the land. Your resilient structure seems remarkably efficient at producing the same result over and over again.
I wrote about exactly this problem in Democracy in America. I said that the condition of black Americans was the greatest threat to the survival of the American Republic. I was not naive about American racism in 1835, and I am not naive about it now. But there is a difference between a system that contains injustice and a system that is nothing but injustice, and you have never been particularly interested in making that distinction.
Because the distinction is a comfortable fiction designed to let people like you, aristocrats observing from a safe distance, feel philosophical about other people's suffering.
Now that we have established our respective temperaments, I am going to do something that may be unfamiliar to you, Jean Jacques. I am going to steelman your position, which means I will present the strongest version of your argument before I take it apart. I do this not because I enjoy the exercise, although I confess I do, but because defeating a weak version of your argument would be unsporting.
How extraordinarily generous of you!
Your position, stated as strongly and fairly as I can manage, is this. The social contract between the American government and its citizens requires that every person have an equal voice in the formation of law. When the Supreme Court removes the tools that protect minority voters from having their political power systematically diluted, it does not merely fail to uphold the contract. It actively violates it. The shift from a results test to an intent test is not a neutral legal adjustment. It is a deliberate raising of the bar that makes it nearly impossible for victims of racial gerrymandering to prove discrimination, because the people drawing the maps will simply claim partisan motivation rather than racial motivation. The effect is identical, but the intent is concealed, and the court has just made the concealment legally sufficient. In your framework, this represents the corruption that inevitably follows when sovereignty is taken from the people and handed to representatives and institutions that serve their own interests rather than the general will. Have I captured your position fairly?
That is a surprisingly accurate summary for a man who has spent his entire career making excuses for the very institutions I am criticizing.
I will take that as a yes, and I will now explain why you are wrong despite being partly right, which is the most dangerous kind of wrong there is.
Very well, then allow me to return the favor and steelman your position before I demonstrate why it amounts to sophisticated complacency. Your argument, Alexis, is that American democracy is not a finished product, but an ongoing experiment. You believe that democratic institutions, even when they produce unjust outcomes, contain within themselves the mechanisms for correction. You point to the abolition of slavery, the passage of the Civil Rights Act, the original Voting Rights Act itself, as evidence that the system bends toward justice over time, even if it does so painfully and with agonizing slowness. You would argue that yesterday's ruling, as troubling as it is, will produce a political backlash that ultimately strengthens voting rights protections at the state level, through legislation, through mobilization, through the very democratic energy that the ruling provokes. You see the crisis as a feature of democracy rather than evidence of its failure. Is that a fair representation?
It is correct, and it is also rather well put, which makes me suspicious of your motives for presenting it so clearly.
My motives are simple. I wanted to present your argument at its absolute strongest, so that when I demolish it, there will be no question that I engaged with the real thing, rather than a convenient caricature.
And there is the Rousseau I expected to meet eventually. The man who believes that demolishing an argument and winning an argument are the same activity.
Your faith in institutional self-correction requires you to ignore the timeline of actual human suffering. You say the system bends toward justice. But the Voting Rights Act was passed in 1965, 60 years ago, and the Supreme Court has now spent the last 13 years systematically destroying it. Shelby County versus Holder gutted the pre-clearance requirement in 2013. Yesterday's ruling gutted Section 2. Your arc of correction appears to be bending backward.
And yet, as I mentioned, and you have chosen to set aside, Maryland enacted its own state voting rights protections the day before the ruling came down. Other states will follow, because that is what happens in a federal system when one branch of government fails. The political energy generated by this decision will fuel organizing and legislation at every level. That is not complacency. That is how federalism actually functions when one level of the system breaks down.
Federalism! You mean the system designed by slaveholders who wanted to ensure that their individual states could maintain the institution of slavery without federal interference. You are asking me to trust the very architecture that was built to protect the system that denied Black Americans their humanity for 2 centuries.
I am asking you to observe that the same architecture was used to end slavery, to pass the 14th and 15th Amendments, and to enact the Civil Rights Act and the Voting Rights Act. The tools are not inherently corrupt. The question is always who wields them and toward what purpose.
The tools are not neutral when the Supreme Court decides who gets to use them and how. Justice Kagan wrote in her dissent that this ruling renders the Voting Rights Act all but a dead letter. She said that states can now systematically dilute minority voting power without legal consequence, as long as they avoid explicitly stating racial intent. That is not a tool being misused, Alexis. That is a tool being deliberately broken so that it can never be used again by the people who need it most.
Kagan's dissent is passionate and forceful, and I take it seriously as an intellectual matter. But dissents have a way of becoming majority opinions over time. The court is not a static institution. Its composition changes with presidential appointments. Its jurisprudence evolves as cases present new facts. What was overturned yesterday can be restored by new appointments, new legislation, or even constitutional amendment.
How many generations of black voters are you prepared to sacrifice while you wait patiently for your institutions to evolve at their own comfortable pace?
That is a powerful question, and I will not pretend it does not give me genuine pause. But the alternative you seem to be proposing, which is what exactly? Abandon representative government entirely. Return to some imagined state of direct democracy where the general will govern 330 million people without mediation. That is not a practical solution. That is a philosophical fantasy wearing the costume of political theory.
It is not a fantasy to demand that a government which claims to represent the people must actually represent all of the people, equally without exception, and without requiring those people to prove that the ones denying them representation did so deliberately, rather than merely by happy partisan coincidence.
On that specific and narrow point, I will confess that the intent standard troubles me. Requiring proof of deliberate racial motivation when the effect is indistinguishable from deliberate racial discrimination does seem to create a loophole large enough to drive a gerrymandered district through. And I say that as a man who generally defends the institutional wisdom of courts.
Then perhaps you are beginning to see that your faith in these institutions is not supported by the evidence they keep producing.
My faith in institutions is not the same thing as faith in any particular institution at any particular moment in history. I have faith in the capacity of democratic systems to respond to injustice over time. That faith is tested by rulings like yesterday's, and I will not pretend otherwise. But I have studied enough of history to know that the revolutionary alternative, the impulse that says burn it all down because it is all irredeemably corrupt, has a rather poor record of producing the equality it promises.
And I have studied enough of history to know that the moderate impulse, the one that says, be patient, and the system will eventually correct itself, has been the preferred excuse of every comfortable observer who has never personally experienced the injustice he is asking others to continue enduring.
We are beginning to raise our voices, Jean Jacques, and I think that is a reliable indication that we should continue this conversation in part 2. Where I suspect neither of us will be quite as measured as we have been attempting to appear.
For once, Alexis, I agree with you completely.